Hello, everyone. Welcome to the 12th webinar of the Grievance Redress and Accountability Mechanism Partnership, also known as the GRAM Partnership. I'm Peter Carlson, a Communications Officer at the Independent Redress Mechanism of the Green Climate Fund. And before I pass the floor over to Laura Waters, our moderator for today's event, I would like to remind you about a few administrative matters. Today's event is being hosted as a Zoom webinar, so you have the option of submitting questions through the Q&A feature, and our panelists will respond to these questions towards the end of the webinar. Also, the webinar will be recorded and published online after the event on the IRM website. For those of you that are new to the Grant Partnership, welcome. The Grievance Redress and Accountability Mechanism, also known as GRAM, is a partnership that was founded in 2019 by the IRM, the Black Sea Trade and Development Bank, and the Social and Environmental Compliance Unit, also known as SECU, of the United Nations Development Program. And the GRAM Partnership is a learning and knowledge platform, as well as a meeting space to share information about grievance redress and accountability issues. It is open to other interested grievance mechanisms, academic institutions, civil society organizations. And if you'd like to know more about the partnership or become a member, you can visit our website. And I'll put the link with more information in the chat in just a moment. With that said, let's start today's webinar. And I'm happy to pass the floor over to our moderator, Laura Waters.
Thank you so much, Peter. And also from my side, a very warm welcome to everyone. Very excited to speak to you today with our experts of panelists. Just to frame the conversation a bit. So we have seen across the last few years and even decades, a very widespread landscape on companies adopting ESG principles, sustainable business principles, and so on. Of course, more guidances have been published, formal directives that could be followed. We've seen significant increase in adoption following the UNGPs and, of course, the M&E guidelines from the OECD. But from a legal point of view, not that much had been adopted just yet. We saw some changes with the German Act coming into law. But of course, the big change came this year when the CSDDD at the EU level got approved and implemented. It was adopted in May after some intense negotiations, and we do foresee it to be a major impact in how companies work on sustainable business and adopt ESG principles. So as of today, we really wanted to host this webinar together with the GRAM Partnership and Amfori to speak a bit about the impact of CSDDD, how we see it moving business, sustainable business supply chains, the stakeholders, what are the implications for overall sustainability, corporate sustainability, and talking about how that can also affect remedy, of course. So joining me on the panel today, we've got three expert panelists that are ready to discuss this further and provide some of their insights. So we've got Valentina Bolognesi, who's a Senior Advocacy and Engagement Advisor, Martijn Scheltema, who's the founder of the Erasmus Platform on Sustainable Business and Human Rights, and Sheila Aluwalia, who's the Director of Policy and Advocacy at Transparentum. And I'll just let them all introduce themselves to you as well, very briefly. Maybe starting with you, Valentina.
Thank you so much, Laura and Peter, for this very kind introduction. I'm very pleased to be here today alongside Sheila and Professor Martin. I'm Valentina Bolognesi. I'm Advocacy and Engagement Advisor at Amfori. And for those who might not know Amfori, we are a business initiative, a sustainability initiative. We work therefore with businesses. Among our members, we have 2,400 companies, and we support them with operationalizing aspects of their due diligence across the ESG pillars, so to say. That is, I think, the background to Amfori engaging in conversations around the EU Corporate Sustainability Due Diligence Directive, since we have been working on some of those topics, supporting companies to do due diligence voluntarily for a number of years, because before, of course, the CSDDD in this case came into being. Do you want me to get started now, or shall we have the other speakers?
I'll just the other panelists introduce themselves as well. So that way it's a nice intro bit, and then we can go on. Over to you, Martijn, for a quick intro.
Yeah, thank you, Laura. And it's a pleasure to be in this panel, and also to see all the people following this webinar online. My name is Martijn Scheltema. I'm a practicing lawyer in the law firm in The Hague, and also the chair of our Business Human Rights Practice Group. I'm also a professor at Erasmus University. That's where the Erasmus platform comes from, and have some other international functions. I'm a board member of the Business Human Rights Lawyers Association, and currently also the co-chair of the European Working Group on Model Clauses, which is intended to develop some model clauses which function with the CSDDD. I will leave it there. Thank you.
Thank you so much, Martijn. And over to you, Sheila.
Great. Thank you, Laura. Hello, everyone. I'm delighted to be here with you today. My name is Sheila Alawalia. I'm the Director of Policy and Advocacy at Transparentum. Transparentum is a US-based NGO that investigates egregious labor and environmental abuses in global supply chains, works with the end buyers of those supply chains to remediate and prevent the identified problems, and then engages with governments and investors for systems change and, when necessary, for accountability as well. I was formerly the Director of Labor Investigations at Transparentum, and prior to that, I spent a decade at the US State Department and also worked at the World Bank and NGOs around the world. Thank you.
Thank you so much, Sheila. So before we go into the topic explanations of our panelists, just a brief note again, and describing what Peter said, you're more than welcome to put any questions, comments, elements you'd like to discuss further in the Q&A. We'll be able to address them at the end of the webinar, or if something really pertinent comes up throughout. So absolutely just opening that opportunity up again. But so for our first bit, I'd like to give the floor to Valentina, who will walk us a little bit to an overview of the directive. How did it came to be historically? How did we get here? What are some of the key requirements and scope, and what can we expect, basically?
Thank you so much, Laura. And indeed, that's the idea, right? To provide you with a helicopter view of the Corporate Sustainability Due Diligence Directive from a non-lawyer perspective. So just also to clarify expectations. And we tried to keep it rather high level, not knowing also about the knowledge of our audience today about this piece of legislation. So if we could move to the next slide, please. Thank you, Peter. So I find it always helpful to a little bit understand where it all came about and how this directive has actually now been adopted, because it has been in the making for quite some time. And I think we have heard about it probably the very first time in 2020, in April 2020, when Commissioner Reinders announced that the intention of the European Commission to introduce legislation mandating companies to conduct due diligence at the level of their human rights and environmental impacts in global value chains. But it was only in February 2022 that the proposal came out for the first time. And because we are, of course, at the level of EU lawmaking processes, this proposal needed to be negotiated also with the other two institutions, notably the representatives of the member states and the members of the European Parliament. So it took quite some time for the other two institutions to also adopt their own vision of how the EU Corporate Sustainability Due Diligence Directive would look like. And that, was basically a considerably different vision than the proposal originally put forward by the European Commission. So that meant that, of course, the two institutions needed to then negotiate and come to an agreement in terms of the final look and feel of the directive. And as you said, Laura, this happened in May this year, when eventually an agreement was possible. If we could move back to the previous slide, Peter, thank you very much. So this agreement was possible in May, and actually the text was published in the official journal of the EU on the 5th of July this year. So this date is important because it actually signals the moment at which the directive enters into force, which happened on the 25th of July this year. But it also signals the point at which the member states will need to have finalized their transposition process, because it is a directive without wanting to go into great detail, but the directive, basically, it's a legal instrument that expects member states to have to transpose the requirements into national law. So this process of the transposition will need to be completed by the 26th of July 2026, and then the application of the rules will only start from 2027 onwards. So there are quite a few things that will need to happen still between now and the first batch of companies having to apply the rules in 2027. Nevertheless, I think an important message to businesses is to start to look into the application and the implementation of the rules now. What I will also mention before then moving into the next slide is that between now and 2027, there is going to be quite some important guidance development work by the European Commission. So the lawmaking process has been completed, the legal text is there, but there is also quite some guidance that will need to be designed and developed by the European Commission on specific aspects of the directive between now and 2027. So moving on to the next slide, thank you very much. So the personal scope, so who will actually be covered directly by the EU Corporate Sustainability Due Diligence Directive. And I say directly because this piece of legislation will have also indirect implications and indirect effects beyond the companies that are directly foreseen to be covered by the obligations. So we look both at EU and non-EU companies. So I think that's a specific aspect of the EU Corporate Sustainability Due Diligence Directive. It covers not just EU companies above certain thresholds, and we can look into the thresholds in a second, but also non-EU companies doing business in the EU above certain thresholds. The application will be staggered, so there will be a progressive application and expansion of the personal scope, but important message to continue signaling that it's about both EU companies, non-EU companies, and there will be also significant indirect implications of the directive. So the numbers are actually up on the screen, and perhaps without wanting to go into those in great detail, what I would want to highlight is that for EU companies, we're talking about two thresholds, the employee threshold and the global turnover threshold. When it comes to non-EU companies, we are only looking at the turnover that actually has to be generated in the EU. So there is also a difference here. The thresholds will need to be actually met for 2 financial years consecutively in order for a company to be considered falling into the scope of the directive. Now, looking at what exactly those companies will have to do, the companies that are in the scope of the EU CSDDD, if we could kindly move into the next slide, please. It is about risk-based due diligence, and actually, yes, we can continue advancing until the end. Apologies for that, Peter. And I think there is a final one, and then we're good. Thank you so much. So risk-based due diligence, that I think is the core of the obligations on companies that are in the scope of this piece of legislation. And the notion of risk-based due diligence is not a novel one. It actually builds not one-to-one, but it builds on relevant international standards on responsible business conduct due diligence, such as the United Nations Guiding Principles on Business and Human Rights, the OECD guidelines for multinational enterprises on responsible business conduct, but also the ILO Tripartite Declaration for Principles concerning multinational enterprises. I know that many would argue that there are some differences between those international standards and the expectations that they set and the legal requirements of the EU Corporate Sustainability Due Diligence Directive. And I think we can have a conversation about those. And there are definitely points of departure, but the point that I would like to make is one that actually conveys the message that a lot of what it is expected of companies is not new. So companies that have been working with those standards in mind will already be in a good position to meet forthcoming obligations stemming from the Corporate Sustainability Due Diligence Directive. If we could still remain, thank you, Peter. But what is it concretely? What does this risk-based due diligence mean in practice? So first and foremost, the integrate due diligence. So that's the first step of due diligence, the one that would, if you're familiar with those international standards, it would be the embedding of due diligence into a company policies and management systems. It's a little bit like a commitment, and then making sure that due diligence is really applied across the different departments and the company management systems. Once this commitment, so to say, is there, companies have also an obligation to take steps to understand how they connect to negative impacts. So the steps of understanding how they connect to negative impacts is usually known as the identification and assessment of those negative impacts. And it's important to stress that the understanding of how a company relates to negative impacts shouldn't be done just at the level of the own company, but also at the level of own operations and also the business partners in the chain of activities. I'm going to cover that in a second. Because it's risk-based due diligence, companies have an opportunity to actually prioritize in case the feeling is that there are, it is really not manageable to address all the adverse impacts at once. Companies are going to be given the chance to prioritize on the basis of notions linked to severity of the negative impact and likelihood. And those are notions that, again, are taken from relevant international standards. The idea is once this identification and assessment and prioritization has taken place, companies will need to take action, and the actions are listed in the directive in the form of appropriate measures. The notion of appropriateness is essential to determine what kind of action actually will I have to take. So there is flexibility somewhat embedded in the way the CSDDD is designed, so that depending on the situation, depending on the level of involvement of the company with the negative impact, basically the action can be determined, the best course of action can be determined. Important for the conversation that we are having also today is that if something, if harm occurs and the company was the one causing the harm or jointly doing so with the business partner, there is an expectation that companies provide remedies. Because due diligence is not an act of perfection, the directive also embeds somewhat the idea of continuous improvement, expecting companies to actually monitoring the effectiveness of their policies and their measures. It's speaking a little bit to the point also of accountability and transparency. Companies also will have to communicate externally on their due diligence. If they fall under the EU Corporate Sustainability Reporting Directive, then somehow the reporting will be considered as covered. Importantly, also for the conversation that we're having today, due diligence is also about engaging proactively with stakeholders. So the stakeholder engagement is actually a component of due diligence and will have to be conducted at specific points of the due diligence steps. And there will also be an expectation that companies set up mechanisms to really listen to stakeholders and to make sure that grievances or complaints can be actually filed through those notification and complaints procedures that the directive talks about. What you see at the very bottom in red, highlighted in red, is actually an additional obligation on companies to adopt and put into effect a climate transition plan. The reason that this is highlighted in red is because it is a little bit going outside of the typical due diligence duty, so to say, but it is a clear obligation also on companies stemming from the EU Corporate Sustainability Due Diligence Directive. Moving on to the next slide. So thematically, when we look at the due diligence duty and the risk-based due diligence, so this methodology of committing and then understanding how, as a company, I connect to negative impacts and then taking action to really prevent the impacts from happening, and then if this is not possible, to bring it to an end. thematically, this very same methodology will need to be applied both at the level of human rights and environmental impact. So what the directive does, it also brings the two areas that maybe in the past might have, in other pieces of legislation, might have been dealt with separately. There is also this convergence of the two thematic areas into one single legal instrument, which is the Corporate Sustainability Due Diligence Directive. So it's about looking at the annex to the directive, part 1, listing the human rights impacts, and those are taken from relevant human rights and labor rights conventions. And when it comes to the environmental impacts, they are listed under part 2 annex of the EU Corporate Sustainability Due Diligence Directive, and they include prohibitions and obligations stemming from multilateral conventions. Importantly, the directive also stipulates a number of environmental impacts that could have human rights implications, and it is what you actually see in the yellow part framed in green. Now, a point, if we could move on to the next slide. Thanks, Peter. I think a point that has been rather controversial in the making of the corporate sustainability due diligence has been the extent to which companies will need to conduct an assessment of risks and impacts beyond their own operations, and therefore to what extent in the value chain. I think the original Commission's proposal talked about value chains, then other proposals from the other institutions were not quite aligned on the very same notion, which is why I think we ended up with the notion of chain of activities, which is a notion that is a little bit new and probably it could be also misleading, and I think the jury is still out in terms of the downstream, whether we're only talking about direct or indirect business partners. But the message that I would like to convey is that definitely companies need to take steps to carry out due diligence, not just at the level of their own operations and those of their subsidiaries, but there's an expectation that actually this understanding concerns also business partners if they are linked to the chain of activities. And what does chain of activities mean in practice? It's definitely the upstream business partners activities pertaining to the design, the extraction, the sourcing, the manufacture, the transportation, the storage, the supply of raw materials, products and parts, and the development of products and services, and also the downstream business partner activities pertaining to distribution, transport, and storage of products. If those activities, I think this is very important, are conducted for the company or on behalf of the company. So this means, for instance, that the disposal, that's usually the example that is given, the disposal part is excluded from the downstream definition of chain of activities. Moving on to the next slide, and I understand that I'm reaching the end of my time almost. So how will this be implemented? How will this work in practice? How will this be enforced? Maybe moving on to point 4, which is the last one actually on the slide, and then going backwards. Collaboration, I think it's a key feature of the CSDDD. If we look at the list of appropriate measures, so I mentioned the notion of appropriateness as something that will need to be assessed every time by the company in question to determine actually what's the best course of action to prevent, to mitigate, to bring to an end an adverse impact. Among the list of appropriate measures, there is also collaboration. The idea, therefore, being that oftentimes companies might not be actually in a position to achieve the intended effect if working alone. So collaboration is also contemplated, as well as in the form of companies utilizing collaborative solutions that might have been either designed by industry or multi-stakeholder initiatives, making it clear, though, that it's not about moving away from responsibility or using those as a shield from responsibilities. As I alluded to, there will be now point number 3, there will be plenty of guidance documents being developed by the European Commission between now and July 2027 or earlier January 2027. There will also be tools that will be developed, including a EU help desk and specific support mechanism for small and medium-sized enterprises, precisely because there is the clear understanding that this directive, despite the fact that it is targeted at large companies, de facto, this will result also in expectations being somewhat also put onto the shoulders of actors that might be in the supply chain of larger companies. Professor Martin will probably speak more about the administrative supervision and enforcement. So each member state will need to appoint national supervisory authorities in charge with the enforcement and the supervision of the rules. The powers of those national authorities will range from investigation to potentially sanctioning companies, all the way up to injunctive measures in terms of asking companies to really either take a course of action or stop ceasing from doing certain things. Last but not least, civil liability is also contemplated, is also a key feature of the whole construct of the CSDDD. What the directive does, it sets the framework, knowing that of course there are then national specificity and regimes that might apply depending on national rules across the member states, but the civil liability is possible if a company intentionally or negligently causes harm as a result of a failure to conduct due diligence. Therefore, there is the right to full compensation that is foreseen and contemplated, which shouldn't correspond to over compensation. But I think it's very important to also stress this dimension of the EU Corporate Sustainability Due Diligence Directive. Now, maybe moving on to the next slide, please. And this was really just to give you an example of what this means concretely in terms of some of the appropriate measures. We can move to the next one. Thank you, Peter. So a company that has identified and assessed the negative impacts that the company connects with, both at the level of own operations and subsidiaries and the business partners. If actually the harm occurs, then what kind of appropriate measures can the company in question have to take to bring to an end and minimize the negative impact? So you see that it's a mixture of corrective action plan, contractual assurances that will have to be verified through audits. It's also about non-financial investments, modifications to sorry, we have moved to the next one, if we can go back. Modification to own business plan. Importantly, also purchasing practices is featured as one of the appropriate measures. So looking also at purchasing practices as one of the appropriate measures that could be taken to bring to an end or minimize negative impacts. I would want to stress again that if the company caused or jointly caused the negative impact, there is an obligation to remediate, and disengagement is also regarded as an option of last resort. So the directive does actually prioritize engagement over disengagement, and there is also an expectation that companies, in the case they decided to disengage, they would assess the pros and cons of disengaging and put into being some actions to actually minimize the negative consequences of the disengagement. Support for business partners. So you see that it's actually sort of a bouquet of options, of actions that could be taken, and depending on the assessment of what it is appropriate, either all of them or more than those could be taken by companies. And this was just to give an example to try to make it a little bit more concrete. We talked about the need to also have to establish, if we could move to the next slide, to establish mechanisms to listen to stakeholders, so not just proactively engage, and that I will talk in a second, but also to listen to stakeholders. So the obligation to establish a complaints procedure and set up a notification mechanism, and maybe moving on to the next one in the interest of time. The accountability dimension, also by communicating externally what is being done on the topic of due diligence, the policies, the processes, the activities, including findings and the outcome of the activity. As I said earlier, in case a company is already mandated to report because it falls under the scope of the Corporate Sustainability Reporting Directive, in principle, there is no double obligation of communicating on top, so to say. And then I think the last slide is probably the stakeholder engagement dimension, which is already a key feature of due diligence. So back to the point that due diligence actually builds on international standard, there is an obligation on companies to take appropriate measures to carry out effective engagement with stakeholders. And that should be done, for instance, when gathering information on adverse impacts, when developing prevention and corrective action plans, when deciding to terminate a business relationship, when remediating, or when monitoring due diligence processes. If we could move to the next slide, I just wanted to quickly sum up some of the concrete sort of implications for businesses from a business perspective. So this directive means that there will be definitely supply chain knock-on effects. Therefore, we need to, I think businesses have to be aware of this directive and potentially of questions or maybe requests for information that could be coming from customers, because the directive really is about understanding how as a company I'm connected to negative impacts along the chain of activities. We talked about the convergence of human rights and environmental impacts into one legal instrument, the need somehow to have also a greater visibility of the supply chain. And while audits, for instance, are definitely mentioned as one of the tools out of the toolbox of potentially appropriate measures, it is clear that actually the directive also wants to include other tools and looks and expects, for instance, that companies would also look at their purchasing practices. Last note, and apologies for taking longer, is indeed the message that much of what it is expected goes back to the international standards on due diligence that possibly companies might already be familiar with. Thank you very much for the time and your attention.
Thank you so much, Valentina. It was super interesting. I see some questions already came up in the chat, which we'll also try and cover at the end. Now, this gives us a really good overview of what the CSDDD is, what we can expect, sort of what impact there may be business-wise. But of course, even when we get to 2027 and that all of this has been transposed, how are we looking at, it's a major step, but how are we going to look at enforcing the requirements? How are we going to be involving all the stakeholders throughout, Professor Martijn? That's really what I would love to get to you for you to shed some light on this.
Yeah, thank you, Laura. And it's a pleasure to tell a little bit more about public supervision and the CSDDD. Peter, next slide, please. Here, we see the same kind of picture Valentina already displayed in her very interesting presentation, which shows the same due diligence cycle, but now connected to the articles of the CSDDD, which implement those steps in the due diligence cycle. One has to note, by the way, that companies are allowed, as said, to prioritize their efforts and also need to implement stakeholder engagement with all these steps. The directive, by the way, is partially maximum and partially minimum harmonization. So that means in the terms of maximum harmonization, especially Articles 10 and 11, so the measures companies have to implement to address potential or actual adverse impacts are the measures that should be transposed. For the other articles, countries have, or member states have, the option to implement, for example, stricter measures. But of course, we will have to see how that will work out in the different member states. But I will now turn to the public enforcement. Next slide, Peter, please. Public supervision, administrative supervision, also as it's also called, I think is very important for the implementation of the CSDDD, because if we have all kind of measures in place which either are not enforced because of lack of budget, because of lack of capacity, or for other reasons, then well, it may become a very kind of well, nice thing to have, but not implementing that much of a change, which it really intends to bring about in terms of what companies do in their due diligence. Well, the implementation of the supervision will be very important, but the problem, as said, may be that, well, depending on the member state at hand, well, their approaches will kind of diverge depending on the budget, capacity, and member state preferences. So it will be very important, I think, for the EU to keep close sight on, well, what happens in the member states, because if this would differ too much, then the level playing field, which the CSDDD also tries to bring about, well, will probably not be achieved. Another very important thing, I think, which the public supervisors should implement, is that what's currently usually observed, especially, for example, by rating agencies like Sustainalytics, others who kind of track the well, company efforts in terms of due diligence, are focusing on company activities. So they send in large questionnaires where all the companies, well, explain what they do in terms of training, in terms of policy, in terms of implementing, for example, stakeholder engagement, community engagement programs, and the like. But all those, well, questionnaires and also the information that's then gathered relates to the company activities. And of course, I do think that many companies really try to do their best in terms of implementing these measures, but whether that really brings about results for the stakeholders this whole thing is intended for is not so clear. And I think that's also why the European Commission and the European Union in the Corporate Sustainability Reporting Directive also focuses so much on also the double materiality, but also providing data on impact on stakeholders, because that's exactly what is needed in terms of taking a next step in due diligence, that we do not only observe company activity, but also results for stakeholders. And there, I think, there's also a very important role for public supervisors in order to check those results and not only the company activities. Because if they would do the latter, what then probably happens that we, well, kind of are checking paper reality. And so a lot of administrative burdens for the companies and for the public supervisors, but probably not that much result. And then I think, well, then the CSDDD may not be very functional. And then maybe already some deregulation voices now being heard in the EU, especially also relating to the CSDDD. Well, and they probably will gain momentum if we indeed start checking paper realities and imposing administrative burdens. But of course, then the next question is, okay, well, that's nice, but how are we then going to implement such public supervision on results? Because it will be very hard for public supervisors to come up with policies which explain what a company has to do in a specific sector, specific country, specific human rights or environmental problem. So the solutions for that, which I have proposed already some time to public supervisors, others, regulators as well, is to implement a best practice approach, which means that we start looking at best practices in sectors which address specific human rights issues, and also in specific countries, for example, and which will implement measures which really bring about results for stakeholders. It may be that those best practices at this point are not sufficient to meet all the requirements from the CSDDD. But I do think that supervisors can have much more effect if they try to get the whole market, or in that sector, of course, at that best practice level, instead of trying to, well, have the outperformer, which already has implemented the best practice, to take next steps to achieve all the results from the CSDDD. And of course, the best practice of today will not be the best practice in a couple of years. So that will be a continuous improvement kind of system. But I think at this point, implementing and steering on those best practices may be much more effective than, well, developing or trying to develop policies on their own, which probably the supervisors do not have budget and capacity for either. So best practice approach and steering on results. The next slide, please, Peter. Well, then to zoom in on the public supervision articles in the CSDDD, well, Valentina already mentioned a little bit about it, so I can be brief here. It's indeed organized at the member state level. Well, the competent authorities in terms of which supervisor is checking which company. Well, it works in such a manner that if a company is registered in a member state or a branch of a non-European country which has its seat in that member state, that's the member state or the supervisory authority, which is then have a jurisdiction over this company. In case of group level due diligence, which is also allowed under the directive, then well, the group holding company can do the due diligence for the whole group, but that does not mean that the authority in the member state of one of its subsidiaries may still exercise supervisory powers as mentioned in Article 25. So then two supervisors will be or have jurisdiction, the supervisor in the seat of the group or the holding company and also of the subsidiaries, as long as they have their seats in Europe. And member states, of course, have to guarantee the independence of the public supervisor. Next slide, Peter, please. Article 25, I think that's one of the important ones because it explains the powers of the supervisors member states have to implement. The supervisors should be or have the power to investigate on their own initiative or because of substantiated concerns, and I will tell a little bit about those later. They should have the power to do investigations, and there, of course, one should note that a lot of the problems which may emerge in connection with the CSDDD and the due diligence implemented by it will happen outside the EU. And so there, the supervisors probably or usually do not have any supervisory powers. So there, they need to collaborate with Global South countries. Not only, I think, by reaching out to the embassies and asking around in terms of, well, what do you think is happening? But what is also very important, I think, if, for example, a public supervisor feels that a certain best practice a company has implemented is really effective, well, it would be very good to also liaise with Global South countries in which these best practices are indeed implemented to see whether they also feel that this does work. And if not, well, what could be changed, for example. So there, I think this public supervision and collaboration with these Global South countries are important. Also, I think to address the issue that many of Global South countries are to date saying, well, it's nice, the European Union is coming up with all kind of regulation, well, which is kind of governing us or saying what has to be done in our countries, but they don't talk to us. So they don't really ask us what's necessary. So I think there the supervisors can also play a role. And maybe, for example, the UN or other international fora can play a role in terms of bringing together these supervisors and the Global South countries, or maybe the European Authority and Global South countries. Then another thing is, of course, that they can also do inspection in the member states, for example, to look into, well, the archives, emails, other kind of information which resides with the companies in Europe. For example, how they conduct their due diligence, how they have prioritized, how they have made their risk assessments. So those are things supervisors can also do in the EU, of course. But as said, it's very important that they do not stop there, because it may be that they, at first at least, try to look into easily observable things like, well, what kind of documentation does the company have in terms of what they do? And of course, it is important, but absolutely not sufficient, I think, especially not if you want to steer on results. Article 25 also explains that if measures have to be implemented by a company, they have to have reasonable time to implement it. And supervisory authorities can order, for example, improvements in due diligence, and also, and that's, I think, a very interesting one, to provide remedy. And especially the latter is very uncommon in most member states to date, because usually the public supervisors are presumed to see to it that in general companies comply with regulation, but not to compensate individual victims of, well, their non-compliance, because the idea is that that should be a thing these victims, either or not in a class action, should do themselves. And so we have seen, for example, in the Netherlands, some administrative courts saying that a public supervisor cannot impose a fine, for example, if a company does not compensate individuals for non-compliance. But Article 25 explains that in connection with the CSDDD, this will be different. So that will be a thing, well, which is quite interesting for the public supervisors also, because they then have to define what kind of remedy should be implemented by the company. And to date, of course, they do not have much knowledge on that, because it's more about civil liability. And next slide, Peter, please. Well, as said, Article 26 implements the option to raise substantiated concerns by anyone who has a reason to believe that the company does not meet its obligations. And that's an interesting one, because there is no limitation on the persons who can do this. So this could be NGOs, trade unions, of course, individual victims, or people representing them. So there is a huge group of people who can raise such substantiated concerns. And I think probably NGOs, trade unions, especially the international ones, will be able to find those supervisors. But that may be much more challenging for individual victims, especially if they are not represented by NGOs or others. Probably it will not be feasible at all for them to reach the public supervisors. So that probably is a thing where public supervisors also have to think about, well, how are we going to also enable those people who are really affected by company behavior to also raise such concerns. And that, well, will not be easy. For example, for retaliation issues, lack of knowledge of what is possible. So there, I think, a big challenge to also have such substantiated concerns. And of course, Article 27 about penalties, because if you have a power which you cannot enforce with a penalty, well, then, of course, well, it does not really make sense. So Article 27 also provides for all kinds of penalties related, for example, to the gravity of infringement, the measures that have been taken, and so on and so forth. Peter, next slide, please. Another important point is, of course, what I already said, that there is a big risk that in terms of budget capacity, the measures the public supervisors will implement really diverge in the European Union. And therefore, Article 28 also implements a European coordinator, which is not a supervisor, because that's are the supervisory authorities in the member states, but it coordinates what these supervisors do, exchange practices, and also can, well, coordinate if, for example, multiple supervisors would be or would have jurisdiction in a specific case. And maybe it can also play a role, for example, in the outreach to global South countries in connection with supervision, especially because I think many of these very large companies the CSDDD governs are operating throughout the EU. So there it makes a lot of sense to have this coordinating body do that outreach. And then the final slide, Peter, please. Of course, we are here in the GRAM community, so a very interesting question, I think, in connection with public supervision would be, well, how does that fit in the existing remedy landscape? And I think there are several connections which can be made in connection with public supervision. The first one, I think, is, well, how does this taps in to civil liability, which the directive also implements? And I think there, for many of the people affected by a company activities, it will be very hard to show that the company has not implemented proper due diligence. Because of course, well, the due diligence is connected to all kind of information and documentation, which is residing with the company, where the stakeholders, of course, have no grip on. And well, it will not be very easy for them to get all the relevant information to prove their case and to show that the company has not complied with the due diligence requirement. But there, of course, if they then raise a substantiated concern with the supervisor indeed identifies a non-compliance, well then in most legal systems, it's already clear that also in civil liability cases that the company did not meet its obligations. And then of course the damage still has to be assessed, but still that will be probably much easier than trying to litigate in court in a self-standing case without such an observation or identification of non-compliance by the public supervisor. And we see this happening, for example, a lot in cartel follow-on cases. So I think there a lot of can be learned from how things function there. But that may be a good thing to do here too. Another thing may be if already some dispute resolution has taken place, for example, NCP, OECD, National Contact Point recommendations have been issued. Well, how does the supervisor implement those? Because, of course, the NCP provides recommendations, which sometimes are based on negotiations between the party and where the parties have agreed on a solution. But, well, sometimes, for example, in the Netherlands, it also issues recommendations where the company is not willing to engage. So there is kind of more self-standing determination by the NCP. And of course, in terms of dispute resolution, well, that will probably not be sufficient to, as a public supervisor, say, okay, well, the NCP has made these and these recommendations, company has not implemented those. So that's also a violation of the CSDDD. Probably much more research by the supervisor, investigation by the supervisor will be needed to make such an assessment. It can also be relevant in terms of what operational level grievance mechanisms or multi-stakeholder mechanisms, because of course, if some non-compliance has been observed there, measures are implemented to redress those. Well, that probably will be also relevant, not only for assessing compliance, but also determining penalties, for example, because if the company already contributed to a solution, that probably also has impact on penalties if non-compliance is observed. And the last thing I want to say here, which is also, I think, very important, Article 12, of course, implements an obligation to provide remedy if a company has caused or jointly caused an adverse impact. But today, the problem is that the remedy is by and large determined by the company itself, because escalation mechanisms in practice are very hard binding. That is, escalation mechanisms are very hard to find for stakeholders in these times. National courts, of course, are an option, but often not a viable avenue. So often it stops with the operational level grievance mechanism, multi-stakeholder mechanism, or eventually maybe even NCP, but all those are non-binding, so the company determines remedy. And it may be that Article 12 does not find such a solution where the company basically defines remedy sufficient. So it may be that public supervisors will start saying, well, you need to do more. For example, as we have seen in the international court, the former Bangladesh court, where such a mechanism in form of arbitration is being made available. So that will probably be a next interesting discussion, I think, in the remedy landscape. Well, how are supervisors going to deal with that issue at this point, and how do they exactly implement the Article 12 obligations for companies? But of course, not clear yet, but that's a very interesting thing I'm going to follow in the future. I will leave it here. Laura, thank you very much.
Thank you so much, Professor. I mean, that's very, very insightful. I think well, following also the presentation before. So thank you so much for this. Moving on to our next, I see a lot of interesting questions coming into the Q&A. We'll address that at the end, so please keep them coming. But of course, first we still have to go to our last, but certainly not least, speaker, Sheila, who has a lot of experience with looking at all some of these impacts that we've been talking about through the course of the webinar. And so I wanted to hear from you sort of what in the past your challenges have been in working on these, identifying them, remediating them, and how the CSDDD could be an opportunity, hopefully as well, to maybe kickstart that a little bit more into gear.
Great. Thanks, Laura. And thank you, Martine and Valentina, for your engrossing presentations. So Martine just spoke a bit about investigations, and I'm going to continue with that. I'm going to discuss some of the challenges of investigating both labor and environmental abuses. And these are challenges that are faced by NGOs like the one for which I work, by trade unions, and by government agencies. And this is also relevant for GRAMs, as they will need to be carrying out investigations for compliance reviews and will face the same challenges. GRAMs may also face some of these obstacles in the problem solving and the mediation stages. So first, it's very important to proactively investigate abuses in supply chains. This is because existing channels to identify abuses often don't work. In general, workers might not trust grievance channels, particularly due to fear of identification and then retaliation. And then traditional audits, which I'll discuss a little bit more later, often don't sufficiently uncover abuses. So organizations like mine, like Transparentum, face a lot of challenges in proactively investigating abuses. We face this at the tier 1 level, and then these challenges are compounded when we are looking at deeper tiers of the supply chain. The really big issue that we face is intimidation. So workers and communities can be intimidated by powerful actors like employers, like developers and industry from speaking the truth. And I can give you an example from one of our latest projects, where workers at investigated factories recently told Transparentum investigators that their supervisors told them that if they spoke out about problems at the work sites, then orders would drop, and then they would become unemployed, they'd receive lower salaries, or they would be sent home to their home countries. One worker said he wouldn't be comfortable sharing his problems with an outsider if they contacted him due to fear of retaliation by his employer, such as being suspended from work or being deported. So in order to get evidence, investigators need to spend ample time building trust with workers and with communities away from the work site and distance from the potential influence of industry or developers or employers. And these challenges are particularly acute for migrant workers who are more vulnerable to abuse and intimidation because of language barriers, cultural barriers, because they might be excluded from joining organizations like unions, and because their legal status is tied to their job. And then for environmental investigations, a specific challenge is that they can require just significant technical skill and also be quite costly. So these challenges that I spoke about are only about investigating abuses, but in supply chain investigations, the need is not just to investigate abuses, but also to trace the supply chain. Connecting these links can be really difficult when companies don't disclose their full supply chains or where import-export data is not disclosed. And then again, of course, these problems are amplified when we're looking deeper tiers into the supply chain. It can be really time-consuming, it could be costly, and it can be risky to access relevant records and to try to track material on the ground. Now I'm going to move on and talk about some challenges of engaging companies and getting remedy from companies. The first one, again, is about poor supply chain tracing. If companies don't have visibility into their full supply chain, then they may question their connection to the abuses that are deeper into their chains. The next one is lack of accountability. Some companies are not subject to accountability regimes, so the reputational risks for them have to be significant enough in order for them to engage in remediation. Voluntary commitments are, far from a fully effective solution, but it does increase the reputational risks for non-compliance. The next point is cutting and running. Companies might choose to just terminate business relationships that have been exposed as being connected to abuses rather than doing the far more difficult work and important work of remediation and prevention. There's also addressing diverse communities. Meaningful stakeholder engagement is really critical in this process. including and identifying appropriate remedy. But communities may not be homogenous. They might not all have the same view. So it could be challenging to gather a community view on both the problem and then also the remedy. And then the last, but certainly not least point of this is the lack of organizing. If workers and communities are not organized, then it's easier for companies to contradict or to discount allegations of violations. So now I'm going to talk a little bit about how the CSDDD will hopefully move this agenda forward. The extent to which the directive will help advance meaningful due diligence in supply chains depends, of course, on how it's enshrined in national law and how it's implemented, including oversight mechanisms and penalties. And the next part of what I want to say might answer the question that Stephanie posed. The CSDDD states that the directive the directive should not preclude member states from introducing more stringent provisions of national law, which is great. But however, in at least one case, we've seen that the opposite is happening. We've seen the German government is partially rolling back its Supply Chain Act requirements to cover only a third of those previously covered by the Act. And their rationale is to align the German and EU law. And there are also examples of countries that had, paused their processes of adopting national laws and instead were waiting for the CSDDD to be adopted to kind of see what they say. But the directive does give European countries and also industry a motivation to lobby for better laws and better enforcement throughout the world. So globally, their business partners and also their competitors will be subject to the same regulations. Ideally, CSDDD can promote a race to the top. I want to highlight some provisions of the directive to show what companies should do as they're working towards compliance. But I first want to make two notes. First, on the corporate level, even in the early stages of CSDDD development, we saw companies and their legal departments being more concerned about compliance and already beginning to take some steps. So this is a great step. And second, I just want to share why this matters for GRAMs. So GRAMs, when they're dealing with supply chain related complaints, are going to be confronted whether CSDDD requirements and then the GRAMs performance standards and social safeguards are consistent, whether the CSDDD requirements have been fulfilled in the projects and also which remedies are appropriate. So now I'm going to talk about some of the provisions. These are in no particular order, and some of these have already been touched on by Valentina. So the first one is beyond tier 1. Since the CSDDD involves the whole chain of activities in a company, companies will need to map their supply chains and then address issues that are deep in their chains. Presently, a lot of companies stop tracing at tier 1, but they have to conduct more robust mapping. And then this mapping just in and of itself will lead to more positive changes. The next point is company-wide sustainability. So the directive makes clear that due diligence needs to be integrated into company policies. This should lead to companies looking holistically at due diligence and sustainability across all departments, not just shelved in the sustainability or CSR or legal departments. And this could also lead to improved procurement and purchasing practices. So my next point is procurement and purchasing practices. The CSDDD directs companies to adapt business plan strategies and operations, including purchasing practices, and to use these practices to discourage adverse impacts on human rights and the environment. This is so critical for companies to implement. So I'm just going to dig into this a little bit. Just want to describe how conventional sourcing practices can put suppliers under a lot of pressure. When buyers are sourcing goods at very thin margins, sometimes below the cost of production, when they are requiring that suppliers are making goods very quickly with favorable financial terms to the buyers, steep penalties for delay, and when they shorten lead times and give last-minute changes to orders, suppliers might not have enough money or enough time to fulfill demands without cutting corners and putting both the environment and workers at risk. So in order for a company to build sustainable supply chains, they have to examine their own purchasing, sourcing, and pricing practices to see how these practices might compel suppliers to violate standards. Standard purchasing practices often undermine beautifully written codes of conduct by the buyers. The next point I'd like to talk about are living wages. So in several places, the CSDDD describes the role of companies in promoting a living wage for employees and a living income for self-employed workers and smallholders, and including but not exclusively related to purchasing practices. Paying living wages has outsized impact on benefiting society, and it could also be seen as a preventative measure against abuse. The next point I want to talk about is audits. So the preamble of the directive describes the need for the European Commission and member states to issue guidance on third-party verifiers to, and I quote this, address the shortcomings of ineffective audits. And they note that merely the use of third-party verification does not absolve companies from penalty or liability. At Transparentum, we cannot overstate our concern about social audits. While audits can be an important tool for workers to bring issues to the attention of companies, there are a few really big problems with audits, including the results are typically kept secret and lack transparency. There's no liability for the auditor, and there could be a lot of fraud and deception. We've uncovered significant audit deception in our investigations. For instance, we've learned of child workers hidden during audits, workers not permitted to speak to auditors, workers being coached on what to say, falsification of records, and workers being intimidated from speaking the truth. We published a report about this in 2021 called Hidden Harm, and I can put it in the chat. But unfortunately, we've seen this problem persist in our project since that time. The system as it is does not work, and companies should not overly rely on audits as a form of due diligence. My next point is stakeholder engagement. The CSDDD directs companies to conduct effective engagement with affected stakeholders, from involving stakeholders in identifying actual or potential impacts all the way to developing indicators for monitoring the remedy of those impacts. It's going to be critical for companies to conduct meaningful engagement with stakeholders, and that the engagement is not just perfunctory. My second to last point is on improved buyer-supplier relationships. So in abiding by the CSDDD, including provisions that companies provide targeted and proportionate support to SMEs that are business partners, companies must use this as an opportunity to foster sustained supplier relationships based on shared values, because a supplier that's committed to protecting labor rights and the environment, and that is supported by its buyers to do so, including financial support, will have little incentive to cut corners. But there's an overarching problem with the CSDDD, and hopefully companies will be able to step in. The directive does not obligate European companies to which it applies to bear the costs of these due diligence measures within their supply chains. And as a result, what's likely going to happen is that the cost of implementing the CSDDD will get transferred to the developing world. And so the poor will bear the costs. Companies have to provide capacity building and technical and financial assistance to SMEs, to smallholders and cooperatives in developing countries. Otherwise, these important actors may end up being excluded from the global economy. My last point is about the grievance mechanism procedures in the CSDDD, and I just want to elaborate a little bit on this, as it might be of particular interest for this audience. So the CSDDD directs member states to require companies to establish grievance mechanisms. While key aspects of the 8 effectiveness criteria for non-judicial grievance mechanisms of the UNGPs are included, notably accessibility, predictability, and transparency, a few are left out or only partially included. This is unfortunate. However, the directive does insist that companies provide the complainant with reasons for finding a complaint founded or unfounded. And this is actually a huge step in accountability, because providing reasons could lead to decisions being scrutinized and challenged. What is positive is that in time, at least some of the effectiveness criteria of the UNGPs will get embedded in European national laws, and this will move these effectiveness criteria from being non-binding to binding, at least for the applicable companies. The grievance mechanisms directed by the CSDDD permits anyone, including NGOs, to file a complaint through their permission of allowing anonymous complaints. So this is an improvement over some existing grants, some of which insist that only the affected individual can complain, and some of which prohibit anonymous complaints. And then my last point is just something that that I'm interested in, that Transparentum is interested in. The directive notes that companies can fulfill their obligations through participating in collaborative complaints procedures. We find the idea of grievance mechanisms that are established and funded jointly by numerous parties very interesting. So I just wanted to pull this out for this presentation. Thank you. Thanks very much.
Thank you so much, Sheila. That was really enlightening, really good addition to the panel. Thank you so much. I think we've seen a number of really interesting points brought up through the presentations. A few key things I've remembered, for example, is that the CSDDD will be applicable both to EU and non-EU companies. So that companies globally should really get ready, that it's building on existing standards, that there's a huge importance of what the impact will be, also in terms of credibility, and that's a lot of organizations are looking at that as well. And that trust is very important towards stakeholders to get their input, but also very much in supplier and business relationships to really help the impact of the CSDDD reach its full potential. There's a lot of questions I have, but I really would like to go, of course, to the questions from the audience first. There's a few I think I can bundle and revert back to the right panelists. Maybe, Martin, for you first. There's been a few questions about the CSDDD, how it's going to be imposed, also towards the southern countries with their supervisory powers, how that sort of conversation is going to go. And that might be a concern as well. So there's two questions, one from Oscar and one from Martin and one from Karen on this. So that way it could be nice to bundle both of those together.
Yeah, thank you, Laura. And I think those are indeed excellent questions because that's currently often happening. And it's also called de-risking, where companies indeed, if in some countries the problems become too big, or, well, there are some specific demands from, for example, governments or local governments or from other stakeholders, well, then it may be easier to just say, okay, well, we're not sourcing again, or not sourcing from such a country anymore or region anymore, and we're going to somewhere else where the risks are not so big, or at least where people do not really know about these risks. And so I think that is not a very good thing to do, and will probably also hamper implementation of good due diligence and bringing about results for stakeholders. So I think it's important, as said, to have that dialogue with Global South countries, but as important, and I think Sheila already also alluded to that, that companies implement responsible sourcing practices. So that means that I think de-risking by just, well, leaving without further notice because, well, maybe become a little bit too risky for a company without also assessing impact of such a measure on, for example, human rights environment in the location which they are about to leave. Well, those are, I think, practices which are not good. And interestingly enough, the directive also includes the option for the European Commission to provide guidance on model clauses for supply chain contracts, because usually these kind of instruments or options to leave are implemented in supply chain contracts where, for example, companies have the right. What they usually try to do, by the way, is shift responsibility to suppliers. So suppliers are responsible for all human rights and environmental compliance, of course, at their cost. Sheila already also alluded to that. And then, well, they are allowed to leave without further notice and terminate the contract if the company does not do, or, well, when a human rights violation, for example, emerges. And that, I think, are irresponsible sourcing practices where, of course, shifting risk, it should be shared responsibility. They should also build capacity, finance what they want, if they want things to happen. Of course, this kind of exiting will probably also not be good. But that's exactly what the European Commission is also about to address in their guidance. And currently also European model clauses have been developed by a working group. They are now open for consultation. You can find them on the internet on the Responsible Contracting Project website. And also on the Erasmus website, by the way. And so these try to implement these kind of more responsible sourcing practices. And I think that will be very important also to address the issue of de-risking, as said, next to the point, I think, that supervisors should also talk to these global south countries. I will leave it there. Thank you.
Thank you very much, Martin. Maybe Valentina, for you, there was a question on that Sheila already briefly touched upon. If there's a way for countries, of course, to individually expand the scope of their particular laws, is there a way for them to potentially go lower initially? So is this directive a floor or a ceiling? What does that mean in terms of applicability of all the different elements?
Thanks, Laura. Indeed, I think in part that has been already answered, but so it's definitely not possible for countries to go lower. So the directive sets minimum requirements that will have to be adopted nationally. Being a directive, there is always, let's say, the inherent risk, if you will, of a divergent transposition process, whereby some member states might go deeper or further than others. In and of itself, because this is a framework directive, I think it is also made very clear that if there is specific laws, specific legislation that actually addresses one sector or one risk in particular, such as deforestation regulation or the conflict minerals regulation. So if there are other pieces of EU law that actually take a more specific and more detailed approach, then the lex specialis should basically take over the general framing that is foreseen by the CSDDD. But to answer the question, there is a maximum harmonization foreseen by the directive when it comes to core due diligence duty related articles, but then there is also an acknowledgement that the member states could go further, but definitely not lower, not offer a lower protection or a lower application of the rules. As an organization, we would favor as much as possible a harmonization of the requirements across the EU27 member states, but this is to answer basically the question. Thank you.
Thank you so much, Valentina. And then there was also a very interesting question that I also leave it up to the panelists, because I feel you all could have very good input here, is if there's any reference to indigenous peoples as a distinctive group with distinctive rights, or any exceptions foreseen, for example, in ways to come forward with claims or in how they should be involved with stakeholders. And if not, are there any discussions to potentially include them in the future?
I can give a brief answer. I just opened the directive to refresh my memory, and indigenous groups are pulled out as a group, a group of members that should be paid special attention to. It also notes the UN Declaration on the Rights of Indigenous People, but that seems to be the extent of the specific elaboration of indigenous groups.
Thank you so much, Sheila. Maybe then for you, Professor Martin, and also Valentina, there was a comment about a Draghi report, which said that the future of European competitiveness is towards simplifying rules, and that there may be some worry for the CSDDD that it will be too much seen within these rules, and that there may be some concern future-wise. Is this something to be taken seriously? Is there a concern that the EU will, at length, at some maybe even weaken or kill the CSDDD?
Thank you, Laura, for the question, and also to Martin for the question. I think only time will tell, but I think there is potentially a risk that I think was it Martin or maybe Sheila that was alluding to the narrative around the overburdening on companies, and how we are seeing this playing out also in other pieces of legislation, potentially the EUDR, the deforestation regulation, and also in the making of the corporate sustainability reporting directive, some delays that were introduced, for instance, to the publishing and the work being done by EFRAG on the sector-specific standards. So I think it's probably too early to say, but I fear for those sort of narratives that might be out there. So that's why I think it's also important to remind businesses of what this directive expects of them, which is, again, building on relevant international standards that have been around, and therefore not expecting companies to do something entirely and completely new. That would be my non-real answer, because I think only time will tell. But I don't know if Sheila or Professor Martin would have a different take on this question.
No, but maybe just to add, I think, interestingly enough, well, the business started asking for this directive because they wanted the level playing field in Europe, because many member states were implementing their own laws. So now the interesting thing is, now we head towards another direction where they try to water it down. Well, that's of course not nice, but understandable. But now even start asking for the withdrawal of CSDDD, where that, of course, will then directly initiate, well, a new unequal level playing field where there's some legislation in some member states. And because I think more and more member states are either implementing reporting the obligation even outside the EU. So I think for companies, there is no way that they will not have to do one way or another, either in connection with reporting or otherwise, some due diligence. So it makes no sense to start asking for it. But indeed, as you say, well, there is indeed some voices now trying to indeed get this withdrawal. But well, I do think makes no sense in terms of level playing field.
Thank you so much. And then there's a final question on indeed, well, the grievances, the redress way, the remedy foreseen in the CSDDD. That indeed, as Sheila pointed out, there's an opportunity for companies to participate in a collaborative mechanism. Just also for the whole panel, of course, Sheila has had some experience, but also Valentina, experience of the members, and also Professor Martin, sort of like from the academic view. Is there any assessment overall on sort of how these budding collaborative grievance mechanisms are functioning, how it works, what the benefits are more versus an individual approach?
Maybe very briefly, I can kickstart this, and then of course the others are most welcome to chime in. So I think it is also encouraged, if we look at the Office of the High Commissioner for Human Rights, they have conducted some research, and they published some conclusions as part of the ARP, I don't know if it's number 3 report, talking also about the supply chain level grievance mechanism that are actually non-judicial, and there is, I think, a recommendation for actors to collaborate and to cooperate, precisely having rights holders at the center and in mind, thinking of what it would mean for them to be confronted actually with multiple similar potential tools and instruments, and therefore thinking of the benefit of coming together and offer a solution that can respond to the needs. Of course, the effectiveness criteria would have to be met, but I think in principle there is an encouragement for those initiatives to come together and to cooperate as much as possible and collaborate, which is also what Amfori is doing with other actors in the market.
Thank you, Valentina. Sheila, Professor Martin, I don't know if you want to supplement.
No, in fact, I had the same question that Lalwanath had. So
okay.
Thanks, Valentina.
Okay, then I just having a quick final look at the questions. Of course, for the audience, feel free to get in touch with the organizer or the panelist afterwards if you have a specific topic you would like to discuss further or anything you would like to expand upon. Just having a few more moments. Maybe Peter, there's any particularities for the audience whilst we still have everybody here about how we will, how the recording will be made available, presentations and so on.
Hello, everyone. Yes, so we will work as we do with all of the Graham webinars, making to edit this video and make it available on the website. We hope to do that next week, and then we will also make the PowerPoint available as well for easy viewing. So look forward to an email that we will send out to give you some information after the webinar with a link to the video once it becomes available.
Perfect. Thank you so much. Then I think, just having a final look, but I think we've covered most of the information. I do for everybody who's interested in some of the things that have been referred on to in the conversation and in the presentations. Peter has posted some elements, so information on the grant partnerships, on studies, and so on in the chat. So please take a look there. I do see two people have their hand up. Is wondering if that is a question. I'm just going to quickly allow them the opportunity to speak up if they do want to put the question that way. So I see one hand up from one attendee. I'll give you the opportunity to speak up. So if you want to, please go ahead and ask your question this way. Well, that must have been a wrong hand then to be up. Either way, if any questions would still come up after the webinar, feel free to get in touch with the organizers or with the panelists. And then that leaves me to thank you all for being here today, for making the time. Thanking a very big heartfelt thanks goes out to our three expert panelists, Valentina, Professor Martin, and Sheila. Thank you so much for shedding light on this. Let's hope to keep the conversation going afterwards, and eager to see what the adoption of the CSDDD would actually bring in terms of positive impact. Thank you all, and wishing you all a great rest of the day.